York Supreme Court indictment returned by a Manhattan grand jury on 34 felony counts of falsifying business records in the first degree. Under New York State law, it is a felony to falsify business records with intent to defraud and an intent to conceal another crime. That is exactly what this case is about. 34 false statements made to cover up other crimes. These are felony crimes in New York State, no matter who you are. We cannot and will not normalize serious criminal conduct. The defendant repeatedly made false statements on New York business records. He also caused others to make false statements. The defendant claimed that he was paying Michael Cohen for legal services performed in 2017. This simply was not true. And it was a false statement that the defendant made month after month in 2017. April, May, June, and so on through the rest of the year. For 9 straight months, the defendant held documents in his hand containing this key lie, that he was paying Michael Cohen for legal services performed in 2017. And he personally signed checks for payments to Michael Cohen for each of these 9 months. In total, the grand jury found there were 34 documents with this critical false statement. Why did Donald Trump repeatedly make these false statements? The evidence will show that he did so to cover up crimes relating to the 2016 election. Donald Trump, executives at the publishing company American Media Incorporated, Mr. Cohen, and others agreed in 2015 to a catch and kill scheme. That is, a scheme to buy and suppress negative information to help Mr. Trump's chance of winning the election. As part of this scheme, Donald Trump and others made 3 payments to people who claimed to have negative information about Mr. Trump. To make these payments, they set up shell companies, and they made yet more false statements, including, for example, in AMI, American Media Incorporated's business records. One of the 3 people that they paid to keep quiet was a woman named Stormy Daniels. Less than 2 weeks before the presidential election, Michael Cohen wired $130,000 to Stormy Daniels' lawyer. That payment was to hide damaging information from the voting public. The participant scheme was illegal. The scheme violated New York election law, which makes it a crime to conspire to promote a candidacy by unlawful means. The $130,000 wire payment exceeded the federal campaign contribution cap, and the false statements in AMI's books violated New York law. That is why Mr. Trump made false statements about his payments to Mr. Cohen. He could not simply say that the payments were a reimbursement for Mr. Cohen's payments to Stormy Daniels. To do so, to make that true statement, would have been to admit a crime. So instead, Mr. Trump said that he was paying Mr. Cohen for fictitious legal services in 2017 to cover up actual crime committed the prior year. And in order to get Michael Cohen his money back, they planned one last false statement. In order to complete the scheme, they planned to mischaracterize the repayments to Mr. Cohen as income to the New York State tax authorities. The conduct I just described, and that which was charged by the grand jury, is felony criminal conduct in New York State. True and accurate business records are important everywhere, to be sure. They are all the more important in Manhattan, the financial center of the world. That is why we have a history in the Manhattan DA's office of vigorously enforcing white-collar crime. My office, including the talented prosecutors you saw at arraignment earlier today, has charged hundreds of felony falsifying business records. This charge, it can be said, is the bread and butter of our white-collar work. And fraud presents itself in all different forms here in Manhattan. We have charged falsifying business records for those who violated federal bank secrecy laws. We have charged falsifying business records for those who were seeking to cover up sex crimes. And we have brought this charge for those who committed tax violations. At its core, this case today is one with allegations like so many of our white-collar cases. Allegations that someone lied again and again to protect their interests and evade the laws to which we are all held accountable. As this office has done time and time again, we today uphold our solemn responsibility to ensure that everyone stands equal before the law. No amount of money and no amount of power changes that enduring American principle. I'll now take questions.
So we're going to take a limited number of questions. There are no follow-up questions. One question per reporter. I will call on you. And again, we have limited time. Thank you. The first question will be Rick.
Thank you. Really representative, why now? Some argue that this is a political move. You're not going to be a political person. If we're going to go into
We conducted a thorough and rigorous investigation, as we're known to do, at the Manhattan District Attorney's Office. I've been doing this for 24 years, and I'm no stranger to rigorous, complex investigations. I bring cases when they're ready. Having now conducted a rigorous, thorough investigation, the case was ready to be brought, and it was brought.
Mr. Bryant, the indictment says that there were 34 false business records. And they were not concealed another crime, but the indictment does not specifically say what those crimes were. We are assuming perhaps that they might be election related. I'm wondering if you can specify what laws were also broken.
Sure. So let me say as an initial matter, the indictment doesn't specify that because the law does not so require. In my remarks, I mentioned a couple of laws, which I will highlight again now. The first is New York State election law, which makes it a crime to conspire to promote a candidacy by unlawful means. I further indicated a number of unlawful means, including more additional false statements, including statements that were planned to be made to tax authorities. I also noted the federal election law cap on contribution limits.
But why weren't there those crimes charged? Why were they charged with those crimes?
Well, I'm not going to go into our deliberative process on what was brought. The charges that were brought were the ones that were brought. The evidence in the law is the basis for those decisions.
You had expressed a year ago that you had some reservations about the case's readiness. Can you talk to us about what were some of the questions in your mind that needed to be answered in order to bring a case of this magnitude?
I'm not going to go chapter and verse into any thinking. What I will say is, I believe the time period you're talking about, I've been in office for a couple of months. The investigation, in my view, was not concluded into the conduct in particular that is the basis for the charges today. Since that time, we've had more evidence made available to the office and opportunity to meet with additional witnesses. As I said earlier, I've been doing this for 24 years. I don't bring cases prior to a thorough and rigorous investigation. Now, having done so, the case has been brought.
Mr. Bragg, Garrett Hake with NBC News. Your predecessor took a hard look at this case and decided not to charge it. Federal prosecutors took a hard look at this case and decided not to charge it. Do you believe you have new evidence that led you to decide to charge this, or why now?
Well, as I just mentioned, we have had available to the office additional evidence that was not in the office's possession prior to my time here. And as to your part of your question about the federal, we have a distinct and strong, I would say profound, independent interest in New York State. This is the business capital of the world. We regularly do cases involving false business statements. the bedrock, in fact, the basis for business integrity and a well-functioning business marketplace is true and accurate record keeping. That's the charge that's brought here, falsifying New York State business records.
Thank you. DA Brett, I'm just going to read that one line from your statement of facts. The participants also took steps that mischaracterized for tax purposes the true nature of payments and furtherance of the scheme. Do you allege former President Trump was one of the participants who mischaracterized the payments for tax purposes?
I'm not going to go beyond the plain language statement of facts, which I think speaks for itself.
Brett, can you please comment on the strength of the evidence that Trump personally intended to violate state election law through the actions that are charged in the indictment?
So the charge is falsifying business records. The charge requires, as I specified, criminal conduct that was concealed. One of the concealed crimes we allege is New York State election law. I sort of went through in our statement of facts, which I think many of you have in front of you, goes through things including, text messages, emails, contemporaneous phone records, multiple witnesses. All of that will be, as you saw in the fall, borne out in a public courtroom in downtown Manhattan.
Last question is Jonah.
Yeah, correct. The charge related to the money payments to Stormy Daniels, the release from your office, also mentions another woman, Karen McDougal, as well as a doorman. Can you comment on how those players are related to the charges you've brought or to the case overall?
I'm glad you put your finger on that, because it's not just about one payment. It is 34 business records, 34 false statements in business records that were concealing criminal conduct. The earlier question about New York State election law, when I talked about conspiracy to promote a candidacy by unlawful means. Those unlawful means, we allege, include the conduct set forth in the statement of facts, which is additional false statements separate and apart from the charged ones in AMI documents, planned false statements to taxing authorities. It is not just that one $130,000 wire payment. Thanks so much.
Any comment about any incitement of violence by former president?
At what point do you think a bad word is necessary?
You've been listening to the Manhattan District Attorney speaking after today's court hearings. Let's talk Karen Friedman Agnifilo. What do you make of what the DA has said and also what the attorneys for the former president have said?
Yeah, so I think the district attorney here is showing everybody that this is a case that has a lot of corroboration, a lot of evidence, text messages, emails, other things. It's not just relying on Michael Cohen. And he was very clear to emphasize that the crime that bumps this up from a misdemeanor to a felony includes at least 2 New York State crimes in addition to a federal crime, because one of the criticisms that has been given to the DA's office and the theory here is, how could you possibly use a federal election crime, since this was a federal election, to bump up a New York State crime? Now, it should be noted that that has been done before under Cy Vance and Robert Morgenthau. There were several falsifying a business record cases that were brought under theories such as this, one of which was a big bank case that involved a lot of money in asset forfeiture, and the bank pled guilty, so it was never tested in court. But it's certainly a theory that's not novel, that's been relied on in the past. But Alvin Bragg, I think, wanted to make very clear that that this here also relies on New York State crimes to kind of take that out of the conversation, take that out of the motion practice, because that is clearly was anticipated to be one of the big weaknesses in the case. It was a legal weakness as opposed to a factual weakness. And obviously, another criticism of the case has been that there have been factual weaknesses in the case because it relied on Michael Cohen. And Michael Cohen, as we know, is somebody who not only has been convicted for lying to Congress, but also convicted of crimes relating to this money scheme, as well as other crimes that he himself committed involving taxi medallions and things that had nothing to do with Donald Trump. So there's a lot of fodder for cross-examination in Michael Cohen, and it's somebody who any good defense attorney could easily impugn him. Yes, exactly. So you need to corroborate anything he says, and I think it was significant that Alvin Bragg was signaling to everybody, making it very clear this doesn't just rely on Michael Cohen. There is a lot of corroboration here, and I think that he's just really taking this. He's just taking certain issues off the table for people who have been speculating all along here.
Ellie?
The core conduct that is charged in this indictment is the payment of hush money. Now, payment of hush money is not a crime. It's not a federal crime. It's not a state crime. So how did they get here to state charges? They're relying on a state law that makes it, in the first instance, a misdemeanor to falsify business records. These are the repayments to Michael Cohen that were falsely logged within the Trump organization as legal fees when they were not legal fees. One of the complicated legal questions here is, in order to bump that up from a misdemeanor to a felony, you have to show that those records were falsified to commit some other crime, some second crime. Now, the indictment does not specify what that second crime is. You heard the defense lawyers, I think rightly, complaining about that. The whole purpose of an indictment is to serve notice on the defendant of what exactly you're charged with and what exactly you're going to be defending yourself against. Now, DA Bragg, again, who was a former colleague of mine, just clarified that a bit. He said federal campaign laws, there's going to be a legal question there. He said state campaign laws. I'm not sure how violations related to a presidential election would count as state campaign laws. There may be some creative argument there. And he did say in passing, and it's mentioned one time in the statement of facts, tax fraud. Now, there's no indication that they actually claimed a deduction. In fact, I believe they did not claim a deduction on this, but perhaps the theory is this was the plan. In terms of the evidence, it is clear that Michael Cohen is the star witness. He is referred to over and over again in the statement of facts. He is quoted at length in the statement of facts during his prior prosecution federally. David Pecker is an important witness too. He's mentioned here. There's actually an interesting mention that he was invited to the White House after the inauguration, and the purpose there is to show this was campaign related. According to the DA, this was not personal. There are documents. They do corroborate the fact that money was paid, but they don't necessarily show Donald Trump's exact involvement in it.
Elizabeth Griffin, I'm wondering what stands out to you. It was also interesting here in this indictment, there's talk that the former president and Michael Cohen that actually were in the Oval Office discussing how to characterize these payments.
Yes, and as Karen laid out, listen, Michael Cohen was always going to be a challenging star witness, but the DA did a good job of laying out the facts that back it up. However, the court of public opinion matters here, and I think the politics that Donald Trump is going to lean into when we hear him speak tonight there are some things that are in his favor here. So the next hearing, according to CNN's reporting, is scheduled for December 4th. So if you're somebody at home who's skeptical of this case, you're saying, so they waited 7 years to try it, then they're waiting about 8 months to have the second hearing on it, and by the way, it's going to fall 2 months before the Republican primary. If you're Donald Trump, you're going to say, it's a witch hunt, it's political, it's a partisan DA. I've also seen some of his folks leaning into the fact that, Alvin Bragg saying nobody's above the law, we prosecute, even these white collar crimes. They're going to lean into the fact that, he's decided to downgrade sub-felony offenses to misdemeanors, things like marijuana, things like trespassing. So there's some fodder here for Trump to push back. We're going to see this play out, but I'm not sure, in my interpretation as a non-lawyer, this is quite as strong as I expected it to be.
David Earp?
Yeah, listen, I've listened to Ellie and others say that if this was all that was there, this is going to be a really weak case. And I think that Joe Giacopini stood out there and said, if this defendant's name was not Donald Trump, this wouldn't be charged. And I have to believe that to be true. I've heard, if this is it, this is going to be weak. It's going to get dismissed. It's going to be a loser. I think Donald Trump's tonight is going to wave this in the air in Mar-a-Lago and say, they're after me. This is a witch hunt, and rightfully so.
Dan?
Look, I think that the DA did something good by presenting this as about democracy. Up until now, everything else was defending democracy in Georgia, the coup, and then we have this weird porn star stuff. Everybody says, what the heck is this? He says, no, this was about corrupting our democracy. It was about corrupting our electoral system. I think in that regard, he helped himself by clarifying that.
All right, a dramatic few hours. Former President Trump indicted on 34 felony counts of falsifying business records. The former national security advisor gives his read on the case against Donald Trump after this quick break.